So if there is a question from the prison authority, the magistrate can put his mobile phone in front of his eye and take a picture of that and send it, and that becomes completely secure then. Even more than uh, the what do you call the system of the UID. Then if all of you have been to courts, have that the dictation, famous dictation thing going on, that how much of it is accurately taken down, and you see the speed of thinking is more than the speed of shorthand, which is sort of a relic of the past. So we have to make a digital system for that also, that how are we capturing dictation, how is it being adopted and done. No rocket science. When you think of the digital economy, this is not really rocket science. These are a few examples which I was giving. Then you see the touchscreen kiosks at the courts and at strategic places, because while you have a bar association, you do not have a litigant association. So the people who are extremely traumatized by this system, who I think we are responsible to, are the litigants and even future litigants. So these touch screens should be there, very friendly touch screens, weatherproof touch screens, where you can access data outside, and there is no premium on information. This is one example of this. Obviously, e-filing of cases, etc. Sanjay has already taken up quite well and given us examples of what is happening. Then you see how many lawyers have tablets and laptops. It's a very shocking statistic, and those are in the Mofussil towns. I'm told that more than 70% of the lawyers are not equipped with computers, tablets, or smartphones. Now, this is something which has to change, and you see, it's like a license that any lawyer has to be e-enabled, and that is what we should request for a financial package, that every lawyer is at least provided with a laptop or at least a tablet to be able to do his work. So I briefly spoke about the personal management system, which is to you know enable more compliance through biometric identification of the staff in the courts, and examples like this. So we are putting together a comprehensive recommendation, and this is just a start. We will have one or two more workshops where the Department of Information Technology and Electronics will also be involved. And I think lawyers who are tech savvy or fascinated by the digital economy, please send in your inputs. There'll be some public consultation by the deity for asking this, and I'm sure the law department is already very seized about all this, and they'll be very seriously taking this forward. Thank you very much, and as you may have some questions, I think we'll take questions for about 5 minutes.
Just a rejoinder I wanted to add to Mr. Mahendru's, very good point he raised. I don't do much criminal practice. My area of practice is mainly commercial and civil litigation, but I do go to sometime criminal courts for some reason. What identification issues and showing the order of the judge, which was fabricated, Mr. Mohindroo raised, is a very serious concern. And I would add to that, which is worth learning from our US experience, that criminal detention centers are directly connected, means the sheriff or the in charge of that with the court system. So the judge will give you a copy of a signed order if you want, only for your satisfaction to keep it in the file. Otherwise, the bail bond is accepted and bail is granted. This will be transmitted to that particular detention center where the detainee is by the system. So there is no paper involved, and before you would reach the hard jail, your detainee is already out from that system. So we have, envisioned that there will be problem of paper fabrication. So from the day one, we do not have. I can tell you from my experience in the immigration courts, because there asylum seekers and many people who illegally enter United States are detained. They may be detained in Arizona, California, or any other state, and I may argue their case in the court before New York, and New York will do the paperwork so good in their computer that it will reach, and my client will call me that I am out, because there is no paper transportation. Either we have to go digital or we have to keep paper, one way or the other. I think duplication will cause some confusion and some sort of problems, like a wrong detainee may be released. So that's one issue I wanted to add on to. Second, something we have to understand very clearly, that courts do not like that their chambers, courts, and proceedings should be violated by anybody, whether attorneys or the litigants sitting in the court. And there are issues sometimes which can be recorded, because all the smartphones have all sorts of recording devices, and you may conflict the court proceeding, or you may interrupt by using your camera, video, or recording device. So you will be surprised to know, from the security point of view, in our court systems, only attorneys, we have a pass to do that, can take any smart device in the courthouse. Rest of the litigants cannot take even their phone, and like a temple, you put your shoes outside, you have to give your phone and take a token for that, so that people may not abuse the court system and may not interrupt while these smart devices. So I do not know whether our courts have adopted this policy or not, but it is helpful, because there is no unnecessary conversation in our courthouses. Lawyers have access to that, and lawyers have such you know disciplinary system that even if I violate, a judge can sanction me, judge can reprimand me, my privileges can be cancelled, revoked, and others. So judges like that, and lawyers do not abuse anything, including the phone talk in the courtroom or the computer use. So this was one thing which I wanted to share with you all.
No, this is, in fact, I did not share it earlier, but video conferencing is critical, important. You see, we find this sometimes amusing, but try to be in the shoes of a prison authority who's taking group of dreaded criminals across states or for trial. It's not an easy thing. So I think technology needs to get instituted there in form of video conferencing. Uh, in particularly in child sexual offenses, uh, for the child to come in the witness stand, it's a very traumatic experience. So there also video conferencing, and something where you are masked, the child is masked from the alleged perpetrator of the crime is there. Witnesses evidence can happen through video conferencing, and this multiple state trial, which is in case of some dreaded crimes like the stamp crime, can also be done through video conferencing. So I think we have a lot to learn from the US and Israel in this matter. Please.
I'm O.P. Gupta, Registrar Construction Industry Arbitration Council. I want to know whether this digital system is applicable and successful in construction disputes. That's all.
Last part of your question.
In construction disputes.
Construction disputes?
Construction disputes, because construction disputes, there are number of things, because we are dealing in the construction arbitration council.
Right.
In construction dispute, whether this is applicable, and if so, how much it has been successful in the past.
I will answer your question, Mr. Gupta. Thank you. There are several independent arbitration bodies, like we have in United States. I do not know all of them, but I practice primarily in New York. New York, we have Engineers Arbitration Association, which does mainly construction dispute. But so far, what I said, it's only applicable by mandate in the federal courts and the state courts. So all other independent bodies are not under the purview of following it, but because of the convenience, lawyers can do this by email to each other. If the arbitrator is comfortable, he will allow them to do this privately, but there is no mandatory rule. In court system, it is mandatory to file electronically, but in arbitration so far, it is not. Yes, sir.
I have two experience. First of all, recently CVC, Central Vigilance Commission, during their Vigilance Awareness Week, I was called upon to speak on how e-judiciary has helped in making court proceeding more transparent in some of the schools.
Right.
That was a very welcome step. But as a practicing lawyer who goes out of Delhi, and I'm not talking of any Mafsil court, I'm talking about state of Uttarakhand, Dehradun Session Court. When I was there handling a murder trial, there I found when I opened my tab or something, I was rebuked by the presiding judge, the session judge, how you are doing all this smart all the digital instruments and all that. So what maybe the bar and other in metros and other towns, those who are in corporate side, but in such matters where the phone, laptop are produced as evidence, unless the judiciary, they are sensitized about this, because my focus is how enable this e-judiciary so that judicial officers, and even this, when I was told, I was talking in this regard, says कि Vakil Sahab, another 5 years, we are not upgrading our system, and still this statement of the witness written by hand. So it's we have to the judiciary, I think, is part of the judicial administration system. So 65th National Law Day we are celebrating, but we have to take our judiciary, mostly lower judiciary, maybe the higher judiciary, to up to that system. They said understand that using this is not a contempt of court or something, smartphone or.
Yeah, thank you very much. I think it's a very, very appropriate comment.
I'm Asha Tapase. I just want to know, I've heard as soon as somebody gets a bail and that person for white collar so-called crimes, even if it's not his fault, he's arrested, and then when he's desperately trying to go, gets a bail, I think it takes him 2 days to come out of the prison because his papers are not there. And suppose he gets a bail at around 12 o'clock on Friday, he cannot come out. 2 more days he has to spend in the jail just because the paperwork is not ready. So how are you going to try? And like Sanjay ji said, I think you should immediately get the digitalization so that the poor guys don't have to stay there till the paperwork is done.
Now, can I add to this, to your question, because it raised a good point here. There are two aspects, and which is worth learning from my New York experience, is that first is the order of grant of bail. that is transmitted ASAP, to the detention center. Now, the second aspect is, in most of the cases, there is a securitization, which means a payment of bond or production of bond. Now, this I'm exceeding my brief, but the bond companies have devised the mechanism and system to do the bond, because we have bond companies which are insured and bonded. So if they send out a wire that yes, this bond is good, that reaches the detention center, that bond has been furnished to. There is financial aspect involved, but both the aspects are, they have the access to go and file a bond electronically, and that reduces our work by, we can get somebody out even on Friday night. And now once the bond and order both are there, you will be surprised to know that our prison system is not interested in keeping a person even on Saturday and Sunday, for the reason that there is a everyday cost of a detainee to maintain, and cost is so huge that people want that if you have a bond and if you have an order of release, I could release you anytime, anywhere, given the time that I have both the things. So digitalization, which is in the first, or I would say primary legs in India, I'm very sure and confident that it will reach very soon that level where detainees, and they will be, not be in the detention center for unnecessary paperwork and delay related to their paperwork. But we have to wait patiently. It will come very soon, I think.
I also request Mr. Mohindroo to do something about digitalizing the people, the youth lying in jails for many, many years without knowing their names, nothing. They are just, even if they are crossing the road of VIP movement,